Thank you, Mr. Chairman. Mr. Chairman, I want to begin by thanking you and Ranking Member Durbin for the letter you sent to the President taking issue with the firing of more than a dozen Inspector Generals without the statutory required notice and case-by-case details setting out the justification for why each was fired. I'm grateful for that important step towards accountability and affirming the law. Whether it is the firing of independent watchdogs or the impoundment of funds appropriated by Congress for the American people, or attempts to amend the Constitution by executive order, if we don't take steps to insist that the executive branch adhere to the laws that we pass, if instead we leave it all to the courts, we might as well go home. We will not be doing our jobs as the founders intended. On Monday, Acting Attorney General James McHenry, at the direction of the White House, fired more than a dozen key officials who worked on Special Counsel Jack Smith's team on cases involving President Trump. Fired them, just like that. Also on Monday, the acting U.S. Attorney in Washington, D.C., Ed Martin, a Stop the Steal advocate and election denier, initiated a review of prosecutors in his own office for pursuing federal obstruction charges against January 6 defendants. The investigation of the investigators had begun. We are seeing similar purges throughout the federal government, but these purges, targeting independent government watchdogs, targeting career prosecutors, dedicated to the principle that no one is above the law, these purges are particularly significant because more than any other, they open the door to rampant corruption, malfeasance, and one-man rule. In a decision that will live in infamy, the Supreme Court of the United States has given the president immunity for crimes committed while in office. And in the case of the Justice Department, that immunity is absolute. And the president will use it and any other invitation to lawlessness that we give him, either in the form of a court decision like that one, or permission, implicit or explicit, that we in this body give him to ignore the law, whether that law pertains to impoundment, inspectors general, federal employees, or anything else. As a bulwark for protecting the rule of law, no position is more important to the country than that of Attorney General. And yet, as a spearhead to violate the rule of law and turn our justice system into a system of repression, no position is more important to the president than that of Attorney General, which is why the stakes are so high with this nomination. Against this backdrop, America needs an Attorney General who will refuse to use the awesome power of the Justice Department against the president's enemies without any factual basis and simply because he wants them to. Someone who has the independence, the stature, the strength of character to say no when she is asked by the president to do things that violate her oath and conscience. She must be willing to speak the truth to power, whether that power is the President of the United States or anyone else. Someone who understands that she is the people's lawyer, not the president's Roy Cohn. Judged by that standard and by her testimony before this committee, Pam Bondi does not meet the test. She just doesn't. During her hearing, I asked Ms. Bondi if she was prepared to advise the president against offering blanket pardons to those involved in the January 6th insurrection, particularly for those who committed violent offenses and beat police officers. Ms. Bondi told me that pardons are at the discretion of the president and that she would, quote, look at every case. She said she would do so on a case-by-case basis. Of course, we know now it is too late for that. On his first day in office and with a stroke of a pen, President Trump issued sweeping and unprecedented pardons for more than 1,500 January 6 defendants, including those charged with assaulting law enforcement. During the hearing, I asked Ms. Bondi whether she had a factual basis to investigate Jack Smith, one of the president's perceived enemies. After a prolonged effort to avoid answering the question, I tried again. Just tell us, are you aware? Tell us, are you aware of a factual basis, a factual predicate to investigate Jack Smith, yes or no? Senator, she said, what I'm hearing on the news is horrible. Are you aware, I tried again, of you seem, she responded, do I know if he has committed a crime? I have not looked. She was not able to tell us what should be obvious, that she has no factual basis to investigate Jack Smith, but instead she told us, "What I'm hearing on the news is horrible. Do I know if he has committed a crime? I have not looked." If this was meant to be reassuring of her obedience to the law and not her obedience to the person of the president, it was not successful. "What I'm hearing on the news is horrible," she said. Yes, it is, and I wonder why. Perhaps, just maybe, it's because this president has been filling the news with false attacks on Jack Smith for years, false attacks that have been endlessly amplified and repeated by others. If this kind of circular logic is what passes for a factual predicate for investigating the president's enemies, no one will be safe. "Do I know if he has committed a crime?" the nominee asked rhetorically. I have not looked. The implication, I have to believe, is that she will indeed look. But look at what? Look for what? Look for a crime? This is not how the justice system is supposed to work. Lest her answer about Jack Smith was an aberration, I asked her about another favorite target of the president, Liz Cheney. I asked Ms. Bondi, "The president also wants to jail Liz Cheney. Sitting here today, are you aware of any factual basis to investigate Liz Cheney, yes or no?" She replied, "That's a hypothetical, and I'm not going to answer that question." But is it really a hypothetical after all the president has said and so publicly about what he wants to see done with Liz Cheney? Perhaps she will look. I asked her if she could speak truth to power, whether she could confront the president with the loss of the 2020 election, and she could not say, or would not say, yes. Having falsely suggested during the campaign as an advocate for the president that he won states like Pennsylvania that he plainly lost, I asked her if she could state, as the plain record makes clear, that there was no massive fraud affecting the outcome of the 2020 election. She could not answer that question with a yes either. If she cannot state the obvious to this committee long after an election, how can we expect her as Attorney General to speak plainly and accurately about an election in the future if it doesn't go her way or the way of her party? Finally, I asked Ms. Bondi if she was ready to commit to preserving the evidence in the January 6th investigation. She was not ready to make that commitment or could not make that commitment. Apart from a vague commitment to follow the law, she could not even commit to preserving evidence of a crime. She said, quote, "I will follow the law." Well, that used to mean something, but then I'm sure Donald Trump would say he is following the law when he tries to amend the Constitution by executive order. In fact, his Justice Department is saying exactly that. Experience is important, and as my colleagues have pointed out, and I quite agree, Ms. Bondi is an experienced prosecutor. But independence, the willingness to speak truth to power, the willingness to say no when a president asks you to go after his enemies, these qualities are essential. Regrettably, Ms. Bondi demonstrated none of these essential prerequisites for the job of the nation's top law enforcement officer. None. I voted no. Mr. Chairman, I yield back.